Hello, everyone. I hope you're enjoying the Business Revolution week so far. We're very excited to be bringing this special event to you, and we thank you for your attendance. My name is John Hannon, and I'm an analyst with Culkin Ginsberg. I wanted to run through a few housekeeping items before we jump into the informative roundtable that we've got for you. First, I want to thank our wonderful sponsors and subject matter experts for their continued support. Without them, none of this would be possible, so we're very thankful to them. Second, I'd like to give a disclaimer. The information that you're about to hear in this roundtable discussion is not intended as legal, financial, or advice of any kind, and it may not be used as such. Advice must be tailored to the specific circumstances of each case. Every effort has been made to ensure that this information is up to date as of the date of this roundtable. It is not intended to be a full and exhaustive explanation, nor may you use this information to replace the advice of your own legal counsel. The speakers assume no liability for any verbal mistakes or other errors contained in this roundtable, or for changes that occur in the future that affect anything that's discussed therein. So without further ado, I'm going to hand it over to Mike, and we'll jump right into this informative roundtable. Thank you.
Hello, everybody. This is Mike Ginsberg, President and CEO of Culkin Ginsberg. Appreciate you all joining us today for this very important topic. We carefully selected 3 elite subject matter experts who are going to discuss with you litigation challenges and strategies in today's unprecedented times. It's critical that we stay on top of compliance in our day-to-day operations. We're going to discuss topics such as litigation related, credit cleanup schemes, call baiting, and false representations. Good morning, gentlemen.
Morning, Mike.
Morning, Mike.
Good morning.
Let me take a moment and introduce our subject matter experts. First, John Bedard. John is the managing partner of Bedard Law Group located in Atlanta, Georgia. He represents creditors, asset buyers, and debt collectors, helping them stay in compliance with state and federal laws. He also manages the nationwide litigation for several collection agencies and focuses litigation practice on FDCPA, TCPA, FCRA, and all of the alphabet soup defenses. John's practice also focuses on defending regulatory actions, including CFPB investigations, and he travels the company performing CFPB readiness assessments for the collection industry. Second in line is Manny Newberger. Manny leads the Consumer Financial Services Law Practice Group, Barron's and Newberger. He's a well-known author and speaker on FDCPA and similar laws, known nationally for his expertise in consumer and commercial law, consulting on FDCPA, FCRA, and TCPA compliance really across the globe, and on the defense of individual and class consumer litigation across the United States. His practice focuses in on litigation, litigation management and strategy, and regulatory defense and compliance, and he serves as a settlement negotiator in many complex cases. Last, certainly not least, Xerxes Martin. Xerxes is a founding partner of Malone Frost Martin with extensive experience in both jury and non-jury trials, briefings, motivation practices and hearings, motion practices and hearings. He believes in thinking outside the box for his approach to develop creative solutions to the client's issues and potential issues down the road. He's handled all facets of TCPA and FDCPA cases as well, from pre-litigation, trial, and appeal, obtaining numerous favorable decisions in the industry. Gentlemen, once again, thank you for joining us. How are you all doing today?
Doing well. Very good, Mike. Thanks for having us.
Absolutely.
Appreciate it very much, Mike.
Manny, why don't you get us started here talking about credit cleanup schemes?
Sure thing, Mike. In fact, there's kind of a broad category. We refer to them as schemes and scams. And
scams, I like it.
We've got a variety of things going on. It's both credit cleanup and debt elimination, both. And you'll see a variety of things. 2 of the things that can make you crazy are the people who are playing games with credit disputes. And you'll see they'll write you and say they dispute the debt, then you send them proof of the debt, then they write back and say, I don't dispute the debt, don't report it as disputed. So then you mark it no longer in dispute, then they write back and say disputed again. And what they're trying to do is they're trying to force you into a misstep where your credit reporting practices don't keep up with their on again, off again disputes. The second one I think worth mentioning is, and I think these are often tied either to militia groups or people who are buying or obtaining forms online from militia groups. There's a fair bit of study on this, and it's scams that involve things like claiming a copyright or trademark in your name. These guys will send you a notice that you violated the copyright in their name by sending them a letter, and that you're now bound to pay them $500,000 for each use of their name. And they've got some theory that if they bill you 3 times, somehow that's a binding contract. We've actually got one guy who's filed a UCC1 on the company assets and the personal assets of one of my collection agency clients. And we are now suing him for declaratory relief that he is engaged in mail fraud. We've actually asked for an affirmative declaration that his conduct is mail fraud in violation of Title 18, as well as injunctions against claiming copyrights in his name and further use of these forms, and to get declaratory relief that the liens are void. And interestingly, the same client's got 2 of them. One actually filed the lien, the other one threatened to file the lien, and we're suing both of them at present. John, Xerxes, are you guys seeing either of these types of scams?
It's been a while since we've had one of them, but her demand wanted us to pay her in gold bullion. I'm not sure if you're saying people have that demand, but we have seen that, and threats to file liens. Fortunately, she did not file liens, and then she really kind of crossed the bar when she threatened to do that for our presiding federal judge too. So that case kind of took a nice turn at that point in time and went away for us. But we have seen those. Frankly, you calling them militia is actually correct. The one woman we were dealing with, the group that she had decided to join was actually determined to be a potential terrorist group. And they kind of are a militia / cult together, and they come up with these things and don't do things the normal ways, to say the least.
Yeah, Manny, we haven't seen the UCC issue in a while. We dealt with that a few years ago, but not really anymore. However, we're seeing more and more of this I dispute, I don't dispute issue. And just as recently as 2 days ago in our office out of the Northern District of Georgia, we got a report and recommendation that there is no claim under the FCRA for failing to remove a dispute when the consumer says, I no longer dispute. And so we're seeing that more, and our clients, thankfully, are pushing back on those claims and defending them, because those claims, in our view, don't have merit. And now we're beginning to get courts to consider those issues and agreeing that, you know, those claims don't have merit. And in fact, the magistrate judge went so far as to accuse the consumer and the consumer attorney of manufacturing these claims, for which the FCRA was never intended to reward.
Well, and I'm glad you mentioned that, because one of the things I always like to point out is that the threshold for getting fees for a defendant under the FCRA is lower than that of the FDCPA, and the FDCPA suits a defendant has to prove bad faith and harassment, but in an FCRA case, I only have to prove bad faith or harassment to get fees. So it's an easier standard. And we've seen this. There was an FCRA case at the Fifth Circuit a few years ago, not mine, but the court actually denied a prevailing plaintiff all of their legal fees because the lawyer manufactured the case. And so I'm very concerned about these, because these are cases that I think need to be fought. I don't know if John, I hear you saying it, Xerxes, I don't know if you agree, but I think these are the ones where you go in, you fight them, you take the depositions, you go after the plaintiffs, and frankly, I think you go after the lawyers for sanctions.
I mean, there's a great line of cases that we're using in a lot of FCRA cases right now that say like how the dispute must come from the consumer. And we know that there's a lot of credit repair agencies, and a lot led by attorneys, and a lot supposed run by attorneys, but they're actually the ones manufacturing these disputes. We're getting deposition testimony from consumers saying, no, I never saw the letter, didn't know what they were saying. There's a particular lawyer credit repair agency that sends out these letters and actually sign their consumer clients' names, sign it then with permission. And so it's hard to say to like deposing a consumer, like that's obviously not your signature. Someone signed it with your permission supposedly, but wait again, you haven't actually seen this letter before too. And so how did you actually dispute this debt? And so there's a good line of cases that say in the FCRA cases, the disputes must come from the consumer. And so we're really pumping those in a lot of the briefings that we have right now in these FCRA cases, because they really do need to come from the consumer. The consumer has to have some meaningful involvement in the dispute process. It has to be a legitimate dispute. And so hopefully we develop those cases more to have some ammunition to go against these manufactured disputes or kind of false disputes in the FCRA world.
No,
Let
and
me ask you
Xerxes,
a question. Let me
okay,
ask
go ahead.
you all the question related to that topic here. Debt settlement companies right now are in vogue. A number of them are growing exceptionally fast. Do you think that they are accelerating this particular event here on behalf of the consumers, or do you think that it's happening another way?
I'll step in on this one a little bit. I'm seeing a lot less debt settlement companies and just more of this credit repair, because it's credit repair. These companies are charging monthly fees. And if they get rid of these debts, they're not going to be able to charge those monthly fees anymore. And then one's tied with attorneys too, attorneys that file FDCPA, FCRA cases. They don't want these debts to go away. They want them to be placed with other agencies, reported by another agency, and just lay the traps again and kind of keep the gravy train going.
And to Xerxes' point, Mike, certainly the what I'll call the major debt management companies, I don't think are the perpetrators. But some of these credit repair organizations are disguising themselves as debt management or debt settlement companies, which they have to do, because if you look at the Federal Credit Repair Organizations Act, you really can't charge people in advance of fixing their credit.
Well, that's exactly right.
For credit cleanup is a serious problem. And the same thing's true under a variety of state credit service organizations acts. So some of them may call themselves debt management companies, but they're not in the same category as the guys who are out there really working with their industry clients to help people pay their bills.
Well, and just to touch upon that, those companies have gone through a tremendous amount of regulation over past years to prevent them from charging upfront fees. Those that are still in business do not charge upfront fees. They cannot charge upfront fees. I mean, that's a huge taboo. So what you're saying is these repair companies may disguise themselves as someone who's a legitimate business, but they're collecting these fees, you call them along the way, the retainers, but certainly upfront as well.
Well, and also there are law firms that, as Xerxes points out, they're doing this to try to set the traps and create the claims. Xerxes and I both have fought with a particular set of plaintiffs' lawyers who write these dubious dispute letters to manufacture FDCPA cases. I've got one case where we've got 4 plaintiffs and they've all admitted they owe their debts and would pay them if they could. Yet the lawyers sent out letters claiming the debts were disputed when the sworn testimony of the plaintiffs is that they don't dispute the debts.
Wow.
And you know, in our experience, that's the beauty of taking the depositions in those cases, because in our experience, those cases completely fall apart once you are able to depose the consumer, and the consumer doesn't even realize that what they're telling you in their sworn testimony actually undermines the entirety of the case. And it's news to them when they learn, you know, hopefully from their own lawyers, that either their case has been dismissed or they lost summary judgment, or God forbid, they're now you know, the target of some motion for sanctions because they filed pleadings that were not true, and knowingly not true. And when those cases come into our office, we're happy that we know that we have a good idea on what the outcome's going to be. But at the same time, we're kind of sad for the client, because now the client's got to go through this, right? And that's really what the client doesn't want to do, is have to go through it in the first place. And so being efficient about taking those cases quickly to resolution and to get those cases to go away is what we try to focus on, because you're right. Once we start deposing these plaintiffs, boy, you know, these claims all go away.
And that's if the attorney can find their client.
Yeah.
And sometimes the plaintiffs are mad at the lawyers.
Yeah.
during those depositions. Sorry, Mike, you had a question.
No, I was just going to switch gears here, John, since you had the microphone. Can you talk a little bit about call baiting?
Yeah. So, call baiting is what we see in our office more and more often. And when I use the term call baiting, what I mean is that there is a consumer or a consumer attorney that is deliberately engaging in communication with a collection agent for the exclusive purpose of getting the agent to say something or do something wrong. And what they do is they are pretty skilled at laying the traps, at planting landmines in places that are designed for agents to step on. And the thing that just sort of grates at us when these cases come into our office is that when you listen to the recording after the fact, a trained agent should have identified the fact that they were the victim or that they were the target of some kind of baiting behavior, right? Because there are hallmarks of consumer baiting that agents should be trained on. And once they begin to see those hallmarks in a phone call, they ought to get off the phone. My mantra is, when the bait gets shown, get off the phone, because nothing good can come out of a telephone call in which the exclusive purpose of it is to get the agent to say or do something wrong. And we really sort of harp on this notion with our clients that you have got to train your agents to identify when they are the target of baiting behavior, because 50%, 60% of the time, they step on the landmine, they spring the trap, and lo and behold, the demand or the lawsuit comes a week, 2 weeks, a month later, and it's all avoidable. It is all avoidable because, the hallmarks of baiting are so obvious these days, and they're so prevalent that we really can teach agents to identify and avoid stepping on the landmine.
That's
For
excellent.
whatever it's worth, Mike, this is a place where you actually want to mystery shop your agents. The call baiting stuff is the kind of thing that, John, you probably do it too. We'll actually phone in pretending to be debtors. Most trial lawyers are frustrated actors, so it's always fun doing this. And the minute they start discussing the topics you tell them not to discuss, they're done, right, John?
Yes.
I mean, we know these scams. So how long is this going to be on my credit report? Can I still dispute the debt?
Yeah.
You can actually find reported cases, Mike, where the judges actually put the transcript of the call in the decision. And, we tend to circulate those, and I suspect John and Xerxes do as well, to the clients, saying, you need to take this and read it to your collectors, because no one should ever have this conversation.
Right.
And I mean, and the training can be kind of streamlined too, because it's probably 98% of the time inbound calls.
Yeah.
So the people handling the inbound calls should kind of have the heightened awareness of these scripts, these topics, and things of that nature. We're handling a case right now where first call this guy had, he refused to identify any information. Then he calls in again, says, hey, you guys keep calling me. And he started fishing around, laying all these traps and everything. And they say, all right, numbers removed. Looks like we're trying to contact the wrong person. Have a good day. Well, he calls in a third time and saying, you guys keep calling me. And so our call note records show that he hadn't even been called that day. He decides to call in 3 times in a row that day to start something. And I mean, for one thing, it's inbound calls. They should have heightened awareness of what's going on here. They can look at the account notes and see this guy has called previously twice today. What's going on here? Then at the end of one of the calls, the recording lasts longer than the conversation, and you hear a third party in the conversation that has not been identified, spoken, or anything. You hear the consumer say, did you get that? You hear, yeah, I heard it, and then hang up. So, and we've got a few cases right now going on where if the attorney is on the phone during the conversation, does the plaintiff have a valid FDCPA claim? And so that one should be decided on summary judgment somewhat soon. And that'll be interesting to see what happens with it.
Yeah. And that's another example where the deposition of the plaintiff really changes the direction of the litigation, because we've deposed plaintiffs and gotten them to admit that when they made that inbound call, they were in their attorney's office. And in fact, the attorney dialed the phone, right? And so when we talk about damage, when we talk about claims, when we talk about all that kind of stuff, those cases really, but getting there is the burden that clients by and large want to avoid. And it's so easily avoidable when we train agents to identify when they are being baited. Because everybody knows, Mike, when somebody's reading to you. You know when somebody's reading something to you. You just know it. And when consumers are reading questions off of a script, when they're repeating the same question over and over, expecting to get a different answer, right? These are the hallmarks of baiting calls that agents should be trained to identify.
John, I'm curious, and Xerxes, Manny, you can answer this as well. Are your clients are they interested? Are they amenable to you helping provide this kind of training and supervision? And Manny, you said something excellent, which is, the mystery calling associated with this. Are they receptive to this? Are they encouraging this proactivity? Or are they just waiting for it to happen to them? And when it happens to them, like any other forest fire, they're trying to put it out before it spreads? Are they being proactive, or are they being a little bit more resistant to these wonderful suggestions?
John, you want to go first?
Sure. So we do, typically what happens in our office is that the claim or the case comes in, and it's usually the chief compliance officer or the chief legal officer that this kind of a claim percolates up to, and they are distant from the training process at the company, right? And so what happens is they too recognize, oh my gosh, this is textbook baiting, and then they make an effort to try and get some kind of change at the company, and there's a bottleneck in some place, and lo and behold, 2 months later, another one comes in, right? And 2 months later, another one comes in. And so the people that we typically deal with agree that we should be doing the mystery shoppers and we should be augmenting our training programs. But for some reason, they're unable to effectuate change at the company in a way that puts their agents in a position to be able to avoid it in the future. That's what we see most often. Other clients are really good at it and they're not victims twice. But I don't see a lot of companies incorporating call baiting into the foundational training of their agents when they first, bring on new agents.
And Mike, I'm inclined to agree. I've had some success at having clients let me mystery shop with them. Those tend to be clients who are really proactive at this stuff. I've similarly had clients let me come in and do mock depositions. One of the things we have found is even the ones who won't let us do the mystery shopping will sometimes let us use the recordings to go in and do training and just dissect the recordings and talk about what went wrong. And collectors relate a whole lot more to listening to a real call than to role playing or even giving examples out of cases. Every one of our clients is recording their calls. We've got the evidence to play for the collectors and let them listen. I actually had one call I used to use that I got from a plaintiff's lawyer where, to John's point, you can actually hear the consumer's tone of voice change and his demeanor changes. And at one point in the call, when the collector is really winding him up, and suddenly the guy's tone of voice changes. And I can tell you what I hear is his lawyer in the background saying, "You tell him never." And the consumer comes back with that in the lawyer's tone of voice, not his own prior tone of voice. That particular call has been on 60 Minutes and Dateline. The plaintiff's lawyer was kind enough to share it with me. So it's interesting to me that you can actually hear it in the calls if you've got the luxury of listening to them carefully with the ears that we litigators have, because we're used to looking for things that are out of place.
Interesting. Xerxes, do you see anything with regard to this? Do you want to add anything to it?
I mean, the agencies that are attending this, that are members of the associations and everything, I'd say they've almost been about as proactive as they can. And at that point, I mean, it's really a shift to being reactive. And you're not really noticing a problem until the lawsuit comes through the door, and you're kind of having to check the policy, see what happened, try to develop what kind of training you can do. Something that's somewhat popular right now is doing kind of the voice analytics and the call mining, having the kind of AI or whatever kind of software, kind of scanning your recordings, looking for certain signs, programming to kind of look for some of these baiting things. I mean, Manny said the hottest couple right now is just like, well, how long is this going to stay on my credit report? There's also the ones of kind of like trying to do sort of the verbal statute of limitations disclosure when an old debt that's barred from being having a lawsuit filed on it, but can still be credit reported in that window. People kind of saying, well, how long is this going to be on my credit? Not sure about how old it is. And then the collector just naturally trained to say, how would you like to resolve this today? Asking for a payment, and then them trying to say that you didn't have any sort of statute of limitations disclosure, which is pretty much required in all letters on time barred debt now. But it doesn't seem like the attorneys kind of generating those claims are wanting to develop case law on it. A lot of times if you tell them to pound sand or something, they're not really wanting to gamble with the courts and really just kind of keep that option open for just settlements, but no lawsuits.
John, you brought up an interesting topic while we were talking about call baiting, and I just find it fascinating that companies invest so much in compliance. They have compliance team, they have outsourced capabilities such as your firms, etc. They're investing considerably in this, yet you're saying that there's a big disconnect in some of these companies between the compliance team, the head of compliance, and these frontline agents being able to detect these important issues, right? Right out of the gate, being able to do this. Do you think that that's going to change, or do you think that there's just a natural divide that needs to be there, or is there, and maybe even intentionally there, between these companies? It sounds like just with some strategic planning and integration between these departments, you could really shore up your own operations quite successfully before bringing in you and the other big guns on this call.
No question, Mike. Call baiting is an avoidable problem. It's avoidable. We can train against being the victim of call baiting. And, you know, unfortunately, what seems to be happening, or at least from my point of view, is that it is changing one company at a time, right? Because when one company becomes the victim once, when they become the victim twice, when they become the victim 3 times, that seems to be the only thing that sparks change. You know, I would love for call baiting to become part of the core curriculum of any training that new hires have to go through at the company, so that they are not victims of this intentional behavior. It is an easily avoidable problem, and the cost of avoiding it is much, much lower than the cost of having to deal with it as a result of not having trained agents for it. Especially when the same consumer or the same consumer lawyer now has you on the radar, right? Because this just doesn't happen one time to an agency, right? We see this happening multiple times to the same agency because they are, you know, they become known as being vulnerable.
Are you seeing it more in a specific asset class than any others? Do you see it in healthcare? Do you not see it in healthcare? Do you see it within financial institutions or telecom more than, say, student loans, which, depending on, you know, what happens over the next couple of weeks with the outcome of the election, may very well, some of them may very well be forgiven anyway. Are there certain asset classes where this percolates more often than not?
You know, I don't think so. Now, I haven't seen it a lot in the student loan area, but I don't think it discriminates. This call baiting doesn't discriminate. What have you guys seen?
I would argue that it's not an asset class per se, but out of stat has a higher percentage than in stat.
Sure. Yeah.
That's such an easy target. Are you going to sue me? Mike, I just want to point out, there was one consumer lawyer who has since moved on to doing other things, who filed while he was doing FDCPA work over 1,000 suits in his district. And an incredible number of them involved the same basic questions. Are you going to sue me? Can I dispute the debt? How long is this going to be on my credit? Over and over and over again. And it reminds me, I used to teach martial arts, and one of the ways you learn to fight with the swords was you had these bamboo strip practice swords, and basically they'd keep whacking you at the spot you weren't guarding till you got tired of getting hit there and learned how to not get hit there. And it's kind of like that.
That's a great analogy.
That is amazing. Xerxes, let's change gears just a little bit here. Why don't we focus in on letters? Manny, you brought up this topic, but Xerxes, maybe you could break the ice and say, what are you seeing different in today's market as it relates to letters, obviously pertaining to litigation management and strategy?
We all know letters. I mean, they're involved in every single account people are collecting on pretty much, except for kind of like the warehouse debt where it's just being credit reported until there's a contact made. Letters are the prime source for class actions against you if it has a problem in it. All of us on this call have handled letter class actions before. They are not fun for the client. I mean, they have the highest exposure. Typically insurance has to get involved, and there's a long tedious case because the attorneys on the other side are hoping it's like their retirement case or something. But I mean, the FDCPA has been around so long, and everyone's done what they can to have the most compliant letters possible. And you'd think that with all of the case law that always comes out, there would be a nice form that everyone can use and not have trouble with, except we've got the other side of the bar out there trying to nitpick every single nuance in every single letter and create some sort of new claim. We're talking about the out-of-stat type letters. Out-of-stat debts had been lettered forever. And only until a few years ago, an attorney decided to say, hey, this letter contains the word settlement and doesn't say anything about a lawsuit. And these people can't file a lawsuit. So settlement kind of implies something about a lawsuit. Let's test the waters and see what a court does on this. And now we've seen that the courts ruled that that is a possible violation, or it is a violation. And now those letters contain the statute of limitations disclosure. So, I mean, it takes a lot of time for these attorneys to kind of create new theories. Everyone was dealing with the Graziano case up in Philadelphia area, where that was the one jurisdiction in the country that kind of found that the copy paste the disclosure language from the FDCPA can actually be a violation of the FDCPA because you don't say in writing there twice. Unfortunately, some good colleagues in the industry took on that case and got Graziano overturned, I believe, at the beginning of this year. And so we don't have to worry about that one anymore. We've had these RE creditor name cases, and they say, oh, you know, there's no entity named Capital One Bank. It's just Capital One Bank. And so it's amusing to see what they come up with. I think the most amusing one right now that we're seeing is kind of in the New York area, saying, hey, this letter contains 2 different addresses in it, or 3 different addresses in it, and my client has no clue where to send a dispute letter on this debt. Because like it'll have like the kind of like a attachment portion you can take off the letter and send a payment in with or whatever. And it's got a return address to a PO box like in the top left in case the letter was undeliverable or something like that. They're saying, oh, my client might have sent a dispute letter there, but they were too confused to figure out which one to do. And so those are creative, to say the least.
Well, wait, Xerxes, I got a client who just got sued because they said which address to use, and now the plaintiff's lawyer says they violated the act because the consumer was entitled to use any of their addresses.
Right. Yeah, and then, I mean, like in, I think we're in a summary judgment in one of those cases now where our client says, yeah, we get it anywhere. They never sent a dispute to any of the addresses. And then like one, we actually like went through the motion to dismiss to show like, yes, here is the envelope that is in the letter they received. if you lay the detachment portion over this letter, you can see where this goes. There's only one address this could possibly go, and least sophisticated consumer, unsophisticated consumer should be able to figure this stuff out. But it is interesting to see what these what has come up with on these.
Yeah. Yep.
But,
You know,
yeah.
Go ahead.
I mean, just the letter cases are unfortunately scary, though, because I mean, it is the source of the highest exposure, that and TCPA in the industry. And then, I mean, sometimes you got to go back to the drawing board, and then you're watching the calendar days pass by for a statute of limitations issue when you fix a problematic letter, and so on. So.
And of course, every letter case is a potential class action because you don't send a letter once, you send it thousands of times.
You know, I tell clients the biggest bang for their compliance buck is getting their letters reviewed by somebody who is skilled at identifying potential defects, right? Whether that be your in-house counsel, whether it be outside counsel, it's your biggest bang for your compliance buck, because you can reduce an enormous amount of risk by identifying just one defect in a letter that you send out tens of thousands or hundreds of thousands of times. The kind of letter defects that we're seeing more often and that I think are most troublesome are not defects that accuse the letter of saying something incorrectly, but of omitting something or implying something that the consumer says is not correct. And so a lot of letter claims that we see are on the basis that the letter does not say something that it should say, or that it implies, albeit with some creative imagination, implies something that the consumer says is false. And, you know, you mentioned statute of limitations, or, you know, things like that, like, oh, you used a word that implies something else is going to happen when that something else is false, right? And having letters reviewed by people who are looking for those kind of things can really reduce an enormous amount of risk for a very low cost,
I do think one thing that's favorable to us right now is the pendulum swinging a little bit in our favor on kind of the materiality requirements in some jurisdictions. But I know we're all using like the Casillas versus Madison Avenue case in a lot of letter cases right now, which is a case actually penned by our new Supreme Court justice, saying that like whatever was allegedly false in the letter, they had to take some sort of action on it. Like it had to have actually caused them actual injury in fact, for like whatever was contained in the letter. Like in that particular case, like it didn't say in writing, well, the consumer never intended to dispute the debt in any way whatsoever. And so they took no action based on what was in that letter. And so these people are actually having to prove up taking some sort of true action or inaction that led to some sort of harm to them. And I think we all know that that is fairly rare in these letter cases. I mean, as John talked about in a case earlier, I mean, just how like sometimes these people like would pay the debts if they could. Majority of the time, they aren't able to do this. They don't dispute it. They aren't able to pay it. They ignore it. And so how are they harmed by a letter containing whatever it possibly contains if there's no action they would be possibly taking on it?
And Mike, this is from a litigation perspective, again, one of the places where investing in a deposition really shows a return on investment, because what these cases are all about, the ones like Casillas that Xerxes mentioning, is that under Article 3 of the Constitution, a plaintiff has to have an injury in fact to have standing to sue in federal court. So the question is, what's the injury? Well, if you file a motion to dismiss the case based on the face of the pleading, the judge has to assume that everything in the pleading is true. So if they allege, as a bunch of them do, that they were injured, the judge is supposed to assume that's true. You go in and depose them, there's a pretty good chance they end up admitting they've got no harm. And now you're ready to come back with that deposition and attack subject matter jurisdiction. You've got a better chance. You know, you can spend thousands of dollars on a motion fight attacking the pleading, only to find out that the judge says, nah, at least for the time being, the case goes forward. Or you can just go take the deposition and come in with a solid motion and get, I think, a better bang for your buck a lot of the time. It all depends on how the pleading is written, how good the adversary is. And frankly, you have to be willing to take the chance they refile against you in state court, because not all the states have this same doctrine. In New Jersey, they can sue you without an injury. In fact, the state Supreme Court has ruled on that. So you got to be very careful about where and how you play the card. But
Manny,
Xerxes is right.
Manny, while you have the microphone here, you and I exchanged notes about time machines, and specifically as it relates to call monitoring. Can you give some guidance as to, what you mean by that, and specifically about how to protect yourself with call monitoring?
Well, and really, it's the recording more than the monitoring itself that I'm talking about when I mentioned the time machine. But sure, Mike, the
Recordings, okay.
yeah. Here's the thing. When I was a baby lawyer, no one on the industry side recorded calls. If there was a recording in an FDCPA case, it was the plaintiff who had it, and it was probably not a good one. Today, everyone records. And this is something I teach my law students to think about, that the swearing match is gone. I can actually say to a jury, ladies and gentlemen of the jury, I want you to understand I have a time machine. And when they start kind of smirking and laughing, I say, no, I'm very serious. We're going to take you back in time, and you're going to witness through your ears or through your eyes sometimes, because I got clients who not only record the sound, but the screenshots. You're going to witness what happened as it occurred in the past. There's not going to be any doubt what occurred on this call. There's not going to be any doubt about who said what, because you're going to get to hear it exactly as it happened. And when you think about these call recording systems and the screen captures as time machines that let you go back in time and know exactly what happened, they take away any doubt. From a case evaluation perspective, it used to be we could be a year into a case and still not really know what happened. We could be past the trial and never really know what happened. Now we know in the first week what actually transpired on that call. And the value of that is incalculable in terms of avoiding bad cases that you shouldn't spend money on to litigate, and figuring out the ones that are worth litigating. I've actually played recordings from one of my clients for a plaintiff. And when the calls were done, I said, they treated you with dignity, didn't they? He said, yeah. I said, they treated you with courtesy and respect, didn't they? He said, yeah. I said, they treated you the way people should be treated. He said, yeah, they really did. And I told my clients, send this deposition to all your clients, because they should know this is how you're treating their customers. The value of that is just astounding to me. I'm kind of curious if Xerxes and John have had similar experiences with this, go back in time and know exactly what happened issue.
I took a deposition 2 days ago, and I had the same script as you right there. It was a very cordial, good call where the guy's saying this is an identity theft, this happened, and she's really trying to help him. She's like, okay, if that's the situation, let me get this packet to you. This is the packet you need to fill out to send to the creditor, and really walking him through it. And she's like, okay, let me confirm your address, we'll get this out to you, that's what you need to do, we'll place the account in dispute status and everything. And so what does he do? He takes that packet, goes hire an attorney, and the attorney sues our client. And so we walk through that and everything, and I just kind of reiterated, you got this packet, you didn't do anything with it. You didn't send it into my client. You didn't send it into the creditor. You just went to your attorney, and then you just file a lawsuit complaining that my client didn't do anything. Well, my client, you listened to the phone call this morning, the 30-minute phone call where she's trying to help you out. And now we're in this lawsuit that you're complaining about too. So that's kind of an interesting take on it. But regarding the time machine, I love Manny's analysis or analogy, and I'm probably going to use that next time. But I had a conversation with a colleague one time, and he just kind of said, I can't believe these agencies record their calls. And I said, no, we want these agencies recording their calls because it shows what did or did not happen. And these recordings are beneficial to us probably 95% of the time. And so we read these allegations that come from these attorneys or the volume filers who don't have the ability to actually know what happens. They just kind of file them on a whim, expecting the settlement shakedown. And we take their pleadings, reread them, and knowing our clients, we said, yeah, we know that didn't happen. We know that didn't happen either. And so we get on the phone, email with them or whatever, and say, well, here's what really happened. Here's our account notes. Here's our recordings. Dismiss, or we'll probably be moving for sanctions. So but the recordings really tell the true story. And I mean, the bad actors in the industry are for the most part not around, or at least not represented by the people on this call, because they wouldn't be around if they're doing those things.
Xerxes, it's more, you're probably saying to them, you're not recording phone calls, instead of the question being asked, are you recording phone calls? You know, it's how can you not be recording phone calls? It's probably the reaction, right?
And it's super important to have a good system that records them. Like you don't have missing recordings every now and then. That's super
like having a good
important.
backup plan.
Yeah,
right?
and then
Disaster recovery comes in many different shapes and sizes. John, you wanted to say something?
I've just observed something in the marketplace that I'm certain you guys have observed as well, which is this phenomenon on how words mutate from the time they leave the agent's lips to the time they enter the consumer's ear. Somehow they mutate, and then when the consumer retells the story to a lawyer, it mutates again, so that what ends up being the allegations in a complaint or an attorney demand are very far from what actually happened on the phone call, which makes Manny's time machine so important. It's exactly why we need the time machine, because this mutation that happens when this story gets retold over and over again is, I think, a huge source of these kind of complaints. And once we go backwards in time and replay the time machine again, now it all is on the table, and we know what the truth is. And I think we might be lucky in the sense that once we do get the recording and we do have a chance to listen to it with the other side, it resolves a whole lot of claims in a case. And there are consumer attorneys out there that, notwithstanding hearing what we've all heard to be the truth, they still press on. Okay, fine. Then we deal with those. But recordings, in my experience, have really come full circle. They help now a whole lot more than they hurt. And that's why we encourage clients to use them as well.
Retention policies, keep them longer than the statute of limitations. So I think we've all seen cases filed the day before the statute of limitations expires. Don't have your recordings just saved for 1 year exactly.
Right.
Have a buffer on it. And then, I mean, you've got TCPA implications too, whether or not someone actually gave consent, revoked consent. So that, like, longer than 4 years there too. Unfortunately, the cost of storage is for the most part considerable, but it's extremely important to preserve this time machine.
And for God's sake, make sure you've got someone who will put a litigation hold so that when you get a suit, you disrupt your normal document destruction policy and don't erase or overwrite the recordings that you need to defend yourself. If you don't have a corporate counsel, make sure someone in the company knows how to do that.
Manny, you brought up this important topic and put out the buzzwords of a time machine. It's just sensational. Anything else about this before we move on to the next topic?
I think that collectors historically were very wary of the recordings. They felt like, Big Brother's watching, they don't trust us. And one of the things I think you can do to really help is, especially whether it's the defense lawyers like John and Xerxes and me, or the company management, when you start talking to collectors about how the collectors are your safety net, the recordings are your safety net, they're the things that save you from the false allegations. They're the things that let us go back and prove what really happened. Because to John's point, it's like the old kid's game of telephone by the time it gets from the actual call to the plaintiff's lawyer. And we can blow away the telephone final version of what was said by showing what the collector really did. They have to learn to like those recordings and appreciate them for what they do for them.
John, that was an excellent analogy. Let's change gears though and talk about false representations, specifically false credit reporting.
So one of the claims, one of the claims that we're beginning to see in our office this year with a lot more frequency are credit reporting claims. Wrong balance reporting, incorrect creditor reporting, reporting bankrupt accounts incorrectly, failing to mark accounts as disputed if the furnisher knows or should know that the account is disputed. we're seeing a lot more credit-related claims coming into our office now, and I think that is due in part to some baiting again in a different kind of way, where some consumers and consumer attorneys are deliberately trying to manufacture some credit reporting claims, but we're also seeing consumers, sometimes legitimately disputing over and over and over and over again, because there really is some kind of defect in an account that an agency is not, that a furnisher is not catching, right? Particularly with respect to identity theft and some what regulators would consider to be more serious claims of credit reporting defects. And so one of the things that we tell clients all the time is to make sure they understand this thing called Appendix E to the regulations for the FCRA. And Appendix E is really the playbook on what a furnisher needs to have in their policies and procedures in order to ensure the accuracy and integrity of the data that they report to the bureaus. When clients come to us and they say, look, we're considering credit reporting, that's when I end up telling them, okay, I understand that's what you want to do, but there's a whole lot you now have to put in place to make sure that you get it right, because you don't want to there is no margin of error or no margin of acceptable error when it comes to reporting accounts in a way that results in incorrect information being reported to the bureaus. And those are the kind of things we're seeing in the credit reporting world and the litigation world right now. And the foundation of it is some kind of false information on a credit report that now causes a consumer and a consumer attorney to bring claims against furnishers, sometimes on a class basis if there's a systemic defect in the way accounts are being reported. One more thing before I stop talking about credit reporting, and that is the degree and the magnitude of heightened sensitivity that regulators around the country are viewing credit reporting issues. I can't tell you the number of Attorney General complaints, FTC and CFPB investigations that we're defending that are focused exclusively on credit reporting. And I am seeing, and I'm interested to know whether you guys are also seeing, a real focus on credit reporting from regulators around the country. It seems to be a hot button for them. It seems to be something that they're really focused on. And we've been helping a lot of clients through investigations that are dedicated almost exclusively to credit reporting.
I think one thing that kicked it off was a certain company and phone carrier released a call blocking app that would try to mark calls like scam call or debt collector or whatever. And when it would pop up debt collectors, say, would you like to block this call? You click yes. And then it would say, would you also like to file a complaint? And people would automatically click yes. Well, hitting that button did two interesting things. One, it sold that person's information to an attorney to contact them to see if they wanted to file a lawsuit. But the other thing it did was it actually sent a boilerplate form complaint to the FCC or FTC, I can't remember which, saying like, oh, I'm receiving harassing calls from this collection agency. And so the volume just spiked on that. And similar things are happening with this credit reporting stuff too, as people are using these services, and a lot of these services are actually developing these boilerplate complaints too about false credit reporting or improper credit reporting or holding my credit hostage. And so those bureaus there are seeing these increased volumes, and it kind of just spins their eyes here or spins their eyes there when they see that they are getting inundated with all of these disputes. They're just boilerplate, but I mean, they're not going through every single one of them. They're just seeing a higher volume in this field. And John talking about onboarding credit reporting, it's kind of fun having to tell a client, all right, depending on volume, you're going to have to hire 1 to 3 full-time employees to handle just disputes. So like not even the portions of just like the reporting and checking. You have to have full-time employees to handle just the disputes and the volume you'll receive on that when you credit report.
Well, and John, like you, I'm seeing the state and federal investigations. We just actually wrapped one at the state level. And I can tell you that the very first CID we ever defended from the CFPB about a year before they were allegedly looking at the debt buying industry was a CID to a debt buyer over compliance with the data furnisher rule. And if your company isn't familiar with that, let me tell you, this is a really interesting one, because the rule actually requires that if you are a data furnisher on consumer reporting data, you are required to regularly update your policies. And this is low-hanging fruit for a regulator.
Yes.
They could just come in and say, show us what you've done to comply with the data furnisher rule. And if you haven't updated your policy in the last 3 years, they've already got you.
Yep.
It is one of the lowest hanging pieces of fruit I have seen in terms of questions we get from regulators is, tell me what you've done to comply with this rule.
That's right. That's right.
Well, this has been great. And as we wrap this up, gentlemen, if you're sports fans, you know that sometimes the talking heads wrap things up with a parting shot. So I would like to replicate that and go around the horn with a parting shot. Who would like to start?
All right,
John,
I'll take it. I'll take it, Mike.
and you were about to say yes anyway, so
That's
we'll
right.
go with you first.
All right, parting shot. Get your letters reviewed. It's the biggest bang for your compliance buck. And if you are a furnisher in the marketplace, you must incorporate Appendix E to the CFPB's regulations to the FCRA into your compliance management system. Bang. There you have it, Mike.
Well done. Xerxes?
Call baiting, trains particularly your inbound agents on this. As John said, the landmines that they can possibly step on. Find the calls, find the problematic calls, play them good and bad calls, play them the calls where there's a problem on them, play them the calls that were handled correctly. Just reinforce it, training, and should be good.
Xerxes, thank you. Manny?
Remember, your only goal in sending a letter is to survive the sending of it. Most people in the industry will tell you that letters don't collect money, people collect money. And yet they'll take on an incredible amount of risk being haphazard in their letters or overusing letters. Every time you send a letter, it's an invitation to a class action because the plaintiff's bar knows it's a form you're using hundreds or thousands of times. So invest in getting it right. Don't play games. And please remember, when we send out these initial notice letters, don't mess with the statutory language. It's a notice letter. The whole point of this is not to collect money. It's to tell people they have rights. And when you try to make them aggressive collection letters, 99 times out of 100, you're going to lose the lawsuit because someone's going to find a creative way to say that you violated the act by getting overly aggressive in what was supposed to be a notice of consumer rights.
Manny, thank you. I have two parting shots. The first parting shot is this. I'm going to call it a news flash or a news break. We live in a litigious society. Is that news to anybody right now? Probably not. We live in an overtly litigious society. This industry attracts a lot of attention, right? But what we're hearing here is a level of productivity. Put yourself out of harm's way by doing some basic things that these gentlemen are suggesting that you can do within your own organizations. Training your agents, your frontline people to detect call baiting. Have your letters reviewed by these experts. Are you crazy, man? I mean, this is absolutely basic 101 defensive measures that we could all take. But here's the problem. We all know we're in a litigious society, but we also are extremely conscious about costs, right? So we look very closely at our P&L and we look up and down our P&L. Well, I am sorry to tell you, this is not an area to nickel and dime. This is an area to take very, very conservative approaches, invest in, be proactive in, to put yourself out of harm's way. These are basic things a lot of people just aren't doing. Spend a few bucks, protect yourself, put yourself out of harm's way. And by the way, you're probably going to save a few bucks in the long run. That's my first message. My second message is one of appreciation. These gentlemen are extremely busy. This is a crazy time. CFPB rules are being declared right now as we speak, right? They're coming out. These guys have a busy calendar. One of them, Xerxes, is out in Vegas today getting ready for a return flight. Better him than me, I suppose. But he's out there, he's healthy, he's doing well, and he's coming back. I will say this, gentlemen, thank you. Thank you for your time. Thank you for your willingness to invest your time and resources back into this industry so people can position themselves and put themselves out of harm's way. It is so critical, absolutely critical. We've had these calls before. It is a moving target. A lot changes in our marketplace, but one constant remains the same. Consumers are very proactive with their counsel when it comes to legal matters, when it comes to positioning themselves to get out of the debts that they owe. We understand that. So why don't you position yourself and keep yourselves out of harm's way, knowing that it's going to occur with proactivity, and utilizing these gentlemen would put yourself in a very, very strong, very defensive position. I want to thank you guys. Again, spending your time with us is very important, and you made time for us today. Greatly appreciate it.
Mike, thanks for having us.
Hello again. That was a wonderful roundtable, wasn't it? I learned a lot from our wonderful speakers, and I'm sure you did too. Before we finish, I want to quickly go over Q&A. If you asked a question in chat and hasn't been answered already, don't worry, you'll receive a response within 24 hours through email or another similar channel from one of our SMEs. In addition, I highly encourage you to connect with our speakers through the platform. They're extremely knowledgeable and they're super excited to share their knowledge with you. So I definitely encourage that. And feel free to reach out to us too, and to Mike, because I'm sure he'd love to talk with you as well. So once again, thank you for attending the Business Revolution Week, and I hope you have a wonderful day. Thank you.